We went there like, oh,
You never tell when they clear the hallways.
it was an indoor.
Yeah, we
outdoor
clear?
place.
Okay. Couple things. With respect to the gentleman I'm going to interview, I need to talk to Neil about that. I don't want to just try to make that happen while everyone's leaving. I need to set that up. That needs to be handled. I haven't a chance to tell Neil what I want to do, so I need to do that. I'm assuming he'll be back after lunch. So you will get a chance to interview him separately in terms of what contact, if any, he's had with the jurors. I'll probably do that when we get right back from lunch before I bring jurors in if he's here. I think that's probably the way to handle it. The second thing is, Mr. Claypool, I need to talk to you about how much more you have to go. I had presumptively set a 2-hour limit on voir dire. However, it is presumptive and you have not wasted time and your questions have been appropriate. And so I can't say that you were doing anything, that didn't need to be done in the case. So I'm going to extend that. You were about 10 minutes away from that 2-hour limit because I think you've been asking appropriate questions at an appropriate pace. But I do need to know how much longer you believe you have on voir dire, what are the topics, and what length of time you reasonably believe it's going to take to cover those.
Thank you, by the way, for the extension of time. I would maybe estimate about 30 minutes.
Okay, that's fine. I know this is an important topic.
Yeah, we covered two core topics, and there's a little couple answers.
No, your questions were appropriate, your pace was appropriate, you were not filibustering, I mean, all that was fine. And so sometimes when I set these time limits, if I see otherwise, I say, well, you've been wasting time. What have you been wasting time? You have not been wasting time, so that's certainly no problem. Okay, what we'll do is, I guess while we're all still here, let me just talk to Neil. Neil, there's a gentleman that has been attending the trial. This is the first day he's been pointed out to me. He usually sits in the back in a bright yellow shirt.
Yeah, we actually watched them walk out.
Yeah, and that's what I want to talk to him about. And so when he comes back into the courtroom, before we bring the jurors in, I want you to indicate to him that the court wants to speak to him, and we're going to call him up to that microphone. I'm not asking you to arrest him, obviously. I just want you to bring him up to the microphone, and so we can talk to him and find out what his relationship is, if any, to, is it Miss Malin? Juror 49?
Yeah, sure.
Malin. Now, just tell me generally, when you say he's been attending events related to this case, can you be specific with me? What you say he's a bit of a quote-unquote stalker, but what specifically do you mean?
I use that term loosely, Judge, but I mystically was someone at their first sentencing hearing. Is that correct?
Okay, so this goes back. This is what I'm trying to understand. This isn't. I mean, sometimes significant other spouses, they will come and see what their spouse is doing for jury selection.
No problem with that.
That's not what you believe the case to be. This is a situation.
That are trial or sentencing, and now is here.
Okay, so original trial, sentencing has been here throughout the course of most of the proceedings?
Every court proceeding since then.
In front of me also? Okay.
Yes, Your Honor. And obviously our concern is...
I got your concern. And Neil, you have observed Ms. Malin with the gentleman?
Yes.
Okay. So that's affirmed for the record. Okay. All right, when he gets back, we're going to bring him in, and I will begin the questioning. Candidly, if it's apparent that he knows about the case, some certain presumptions will, of course, apply to Ms. Malin about that. But I also want to make sure he hasn't spoken with anyone else about the case. So we'll do that when he comes back. I just wanted to set it up. I didn't want to just create a scene while the trial was going on. Okay. All right. So we'll be in recess until 1:30. The motion to suppress with the videotape interrogation of Mr. Dippolito, and a motion to suppress the car video.
Well, I believe we had a hearing on the one with the interrogation.
Right, and I can just rule on that. I can give you a ruling on that. you asking about the other one?
Yes, I didn't really have to hear it. The state contemplates something yesterday.
Well, I don't know what other evidence everyone's relying upon. If the state is relying upon the testimony that has been previously proffered by Mr. Shaheda, because he's the one that would have to be given consent, both the motion to dismiss and at the trial and at the deposition of trial, I think I could probably rule on that basis if that's his testimony. If there's additional testimony anyone wants to offer, I'll be happy to hear it.
No, the only thing, Judge, was that we don't think you heard what he said on the tapes. Because Ms. Lord is saying that, well, he's saying what I want to play for you. Mr. Roosevelt was talking about what is the portion that I want you to get.
I need to, well, Mr. Roosevelt objected to it because it was also part of the Arabic. I mean, I guess I'll let you replay it. Let me tell you what, I mean, I'll make a ruling, I guess, on that after lunch break if you want to replay it. My ruling on the interrogation is sort of a mixed bag. It's a granting part and denying part, the way I looked at it. I reviewed both of those interrogations. I don't think there's a basis to suppress both of them based on the fact that the cops' production crew was outside and all of that was going on. So I don't think there's a basis to suppress them overall on that basis. However, in reviewing the first interrogation, this is the interrogation where they bring in the undercover officer, they have Mr. Dippolito. Candidly, on a 403 basis, I would suppress it. I'll give the state an opportunity to tell me how there's really anything in that which is more, the other interrogation is just like any other interrogation. The second one looks like just any other interrogation you'd expect in any other criminal case. They sat him down, Miranda was reaffirmed, went through, said this is what we know, they played portions of tapes, it was consistent with what you would expect what I see every day of the week. The first one wasn't. The first one looked more like a show to me, frankly.
First of all, they're asking her who would want to kill a president.
Correct.
And they tell her that they arrested a guy coming out of her house.
Right.
They bring Mr. Wade Jean in. And she denies ever seeing him. She just spoke to him the day before and spent a good half hour of the prior day before that.
Correct.
That is absolute consciousness of guilt, Judge. Absolute.
Well, I will consider it, but I'm concerned about that first video, because that first video, the way that it was conducted, suggests to me that it could have been done more for the purposes of show than it was for the purposes of actual police work. I understand consciousness of guilt and ask whether you recognize this person and her denying it. I think she was asked the same questions without him in the room in the second interrogation, and she denied also in the second interrogation. So that's the concern. It's a 403 concern. I don't think argument, but that's my concern as to whether the prejudice is, and there really isn't any admission that comes out of it. It's just the state making its presentation and the denial. That's
The
it.
point more than that, Judge. They're claiming this is a stunt. If this is a stunt, none of that stuff matches up with the stunt. That like every bit of what she said.
Well, that's true if that's the defense. Hear me out, Mr. Evans. I mean, there are things that are not admissible in case in chief that are admissible in case in rebuttal. I don't know at this point what their theory of defense is going to be. There are two possible that come to mind. They're somewhat inconsistent, candidly. That it was a show goes to intent. There was no crime because there was no intent. Entrapment is another possible defense. Entrapment is an admission and avoidance. It's an affirmative defense. You admit crime, but you say the crime was committed because of actions of law enforcement. So those theories are a little inconsistent. One goes to initial intent. There was no intent because it was a show. The other goes to it's an affirmative defense, admission and avoidance. That's what an affirmative defense is, admission and avoidance. We admit a crime was committed, but it was committed because basically law enforcement action compelled us to do it where there was no predisposition. So those are a little bit inconsistent. My point simply is, Mr. Williams, sometimes something might not, from my viewpoint, be admissible in the case in chief, which might be admissible in a rebuttal based on theory of defense. So it's a long way of giving that answer. Okay. Nevertheless, we're in recess until 1:30.
Any other motion before we go with that?
I'm going to let him play what's left of that tape so I can hear it, and then I'll make a ruling on the motion to suppress. I think that's all we have left. Okay, we're in recess. On track. Probably not. I'll talk to the lawyers when we get back out there. Probably not.
The other one is in, I mean, he needs a copy of what's the other part of it. Yeah.
Which one is this the first one I gave you?
Not the first one I gave you, it's with the guy you told me from the method.
Okay.
That's